Hi, good afternoon, and welcome to my fellow Minnesota State Bar Association members. My name is Magdalena Machalska. I'm the chair of the Immigration Law section, and I'm excited to be moderating the first session of the new Rule of Law CLE series, How Lawyers Can Prepare Their Corporate Clients for Immigration Site Visits. Presenting this program is my friend John Medeiros, shareholder and head of corporate immigration at Nillen Johnson Lewis. John represents companies of all sizes, from Fortune 500 to small startups, in a vast array of industries, focusing on employment-based immigration. John has served as adjunct professor of immigration law at Mitchell Hamlin School of Law and organizes legal education seminars for corporate clients and presents each year to foreign students on immigration options after graduation. Before we get started, I have a couple of housekeeping items. If you're interested in more sessions in this series, you can check out the chat where we will be posting the upcoming sessions on the Magna Carta and constitutionalism and navigating legal threats to nonprofits. If you have questions for John, please use the Q&A function to post your questions. We will try and answer questions at the end of our session, but go ahead and send us your questions now or whenever you have them. Our event code for today, whenever you're ready, is 528525, and it has been currently pending approval for one standard CLE credit. We anticipate approval within the next couple of weeks, and we'll put the code in the chat later in the program. If you have comments, you can post those in the chat. And with that, I will turn it over to John. John, whenever you're ready.
Thank you so much, Magdalena, and thank you everyone for registering for this presentation today. I understand that there are over 200 of you, which is really impressive for me because we sort of put this together, what I think of as rather last minute. So I'm impressed with your responsiveness, and I'm impressed with the MSBA's coordination of all of that. Thank you to the MSBA and to the Immigration Law section of the MSBA. As Magdalena said, my name is John Medeiros. I lead the corporate immigration practice here at Nillen Johnson Lewis. I will also say very briefly that I'm the former chair of the Minnesota Dakotas chapter of the American Immigration Lawyers Association, and I currently chair the faith-based working group of the local chapter. And I say that because in both of those capacities, I received a lot of questions around the topic that we'll be talking about today, which is how to prepare for corporate site visits by the Department of Homeland Security primarily, but also maybe by the Department of Justice. Before I switch over to the PowerPoint slides, I just want to add that the genesis of this topic originated many years ago, 2017, I believe it was, when many of us in the immigration bar were concerned about how the administration would be conducting enforcement activities, particularly since that was a strong component of the campaign. And we got a lot of questions from mostly nonprofit employers, but not only nonprofit employers, about what that might look like and how to prepare for that. Then that interest was rejuvenated in January of this year with the incoming administration that has again promised to ramp up enforcement activities. And so we are now getting an influx of questions from employers on how to prepare. And I want to make it really clear that the target and the intention, I guess, of this presentation is to address the needs of the corporate entity, the employer, as opposed to the individuals who might be employed or patients of the employer or customers or guests. It's more about the obligations of the employer and what the employer needs to keep in mind to prepare for a site visit. So with that, I'm going to share my screen. I think I'm going to do it successfully too. I'm going to share my screen and we'll get the presentation underway. Can you all see that okay? Somebody, yes?
We can see it, John.
Great.
Yep.
Thank you so much for confirming. So we want to talk a little bit about how lawyers can prepare their corporate clients for immigration site visits. So the target today, the target audience are lawyers who have corporate clients. And my hope is that with this presentation, those who attend would feel compelled and knowledgeable and invigorated to give similar presentations to their corporate clients as well. So let's start with how we got to where we are today. We all know that on Inauguration Day, President Trump signed a number of executive orders, and about 10 of them were specifically related to immigration. And the one that is I guess the one that paves the way for all the policy changes that we're seeing with this administration, one of the more noteworthy is the executive order that's entitled Protecting the American People Against Invasion. And what this executive order does, a number of things, but I call out those that are more applicable to what we'll be talking about today. One thing it does is it directs the Department of Homeland Security to prioritize enforcement of federal laws related to the legal entry or unlawful presence of immigrants in the United States. And we've seen that already begin to happen. We've seen the large numbers of removals from the United States. We've seen large numbers of individuals whose statuses have been revoked while they're here in the United States. Another thing that it does is it calls for significant increases in the hiring of Customs and Border Protection or Border Patrol agents and Immigration and Customs Enforcement personnel, ICE agents, notwithstanding the hiring freeze of other federal personnel. So we've seen in the news that there's a lot of federal employees that have been terminated from their positions. We've seen and we've heard of government statements saying that they are not going to be hiring additional personnel. But what we've also seen is that those provisions don't really apply to enforcement. We are seeing an increase in enforcement. In fact, just last week, there was an announcement that in the United States, will be seeing a market increase in enforcement activities, particularly in work sites, particularly in locations and cities that have separation ordinances, which we'll talk about in just a few minutes. But basically, that refers to cities that have agreements that they will not collect immigration status related data. They will not use their law enforcement to collect that data. And Minneapolis and St. Paul both have separation ordinances. So Minneapolis and St. Paul and employers in those cities can expect to see significant increases in the enforcement activities that happen in those jurisdictions, in those locations. What we're also seeing is that the administration appears to be removing the legal status of many lawful immigrants. I'm sure you've all seen in the news, a lot of students have had their student visas revoked. Many people who have entered the United States from Cuba, Haiti, Nicaragua, and Venezuela as parolees, over 500,000 people have had their statuses revoked, even though their statuses and the documentation they have say that they're authorized to be here through at least next year. We're also seeing those being revoked. There have been court challenges to that, and that has been put on hold. And we're starting to see something similar with students. And so things are changing all the time. But what we're seeing with the administration is not just we're going after those people who are undocumented, but we're actually going after people who are here lawfully, and we're removing their lawful status and then commencing removal proceedings. And so with the students, you've seen they've been on college campuses, they've been in locations that might be clients that you all represent today. For those of you who represent nonprofit clients, if you aren't aware of the sensitive locations policy, this will apply to you, something to be aware of. So for the last 30 years, our government has had a policy called the sensitive locations policy, which basically said that under very limited circumstances where there was an imminent threat, the Department of Homeland Security would not conduct enforcement activities in sensitive locations. And those locations include places of worship, congregations. I'm getting a lot of calls from mosques and churches and synagogues around this very thing. The policy also said they would not conduct enforcement activities in schools, including colleges and universities. They would not conduct enforcement activities in sites of religious ceremonies, such as weddings and funerals, or sites of public demonstrations like parades, and hospitals and healthcare sites. Well, all of that was rescinded in January by the acting Secretary of the Department of Homeland Security, where they rescinded that sensitive locations policy. So there have been challenges, three challenges particularly. There was a challenge brought by a group of Quakers in the northeastern part of the U.S. That the district court ruled in that case that the plaintiffs who were suing the administration had standing, and that the enforcement activities would not happen, but it was only limited to the plaintiffs of that case. There was another case, primarily a group of Mennonites, but a lot of state councils of churches also joined that case, and that was in DC. And just, I believe it was last week or the week before last, the judge ruled that the plaintiffs did not have standing because they couldn't actually show that there was any harm, even though they could show that there was a marked decrease in attendance in those congregations. So that case did not go well for the plaintiffs. And then there's a third case, the Denver Public Schools, which is still pending. And that's again, we mentioned schools as being part of the sensitive locations. That case we're still waiting to hear from. So there are some challenges to this, but for the most part, what the administration has said at this point in time is that they will use common sense to conduct enforcement activities. We don't know what that means, but that's the language that they've used. So we know that there are some entities that are vulnerable to raids, and now we know there are even more that are vulnerable to raids given the rescission of the sensitive locations policy. So let's talk a little bit about what is a Department of Homeland Security or an Immigration, Customs, and Enforcement raid. The term raid is used to refer to ICE agents who go to a work site without notice as part of an investigation. I think that is probably something we all know, but the takeaway here is that they're not usually with notice. There are some site visits where the Immigration Service does give notice, but a raid is not one where you would typically see that. The raids often target individuals suspected of being in the United States without authorization. So they don't really they're not really targeting employers, but like I said just last week, the Department of Homeland Security's I think he's called like immigration czar, something like that. He announced that the Department of Homeland Security announced that they will be doing more enforcement at more employer work sites. But again, the target isn't really to go after the employer as much as to round up as many people as they possibly can. And then, as I said earlier, local police officers or agents from other law enforcement agencies, they can accompany ICE agents on ICE raids, but St. Paul and Minneapolis both have separation ordinances that prevent that from happening. So you may have employers in other parts of the state that do allow that, do use their local enforcement to carry out raids with the federal agents. There's some concerns about that because federal agents, for one, have to go through extensive training in order to make sure that the raids are carried out or consistently with statute and with the Constitution. And when you use local law enforcement agencies to do that, they don't always have the same training that federal agents have, and that can be problematic, particularly with respect to respecting human rights. And so we're starting to see those kinds of agreements open up. And again, this is part of the executive order that allows for more of those agreements. And like I said, last week, the Department of Homeland Security has said that they're specifically targeting employers that are located in jurisdictions that have these site separation ordinances. Now, as I said earlier, there are other types of site visits that your clients may see, and they can be carried out by different agencies within the government. The first two are I-9 visits, and I'm sure most of you know what that is. But very briefly, I'll say the I-9 form is an employment verification and a form that every employer has to complete for their employees, and the employee has to complete it as well. And that's where the employee provides documentation to show their identity and their authorization to work in the United States. And those I-9 forms are kept on file and available in the event of an audit. Now, there are two agencies that typically audit I-9s. They can be the Department of Justice, the Immigrant and Employee Rights Division, or they can be ICE, Immigration and Customs Enforcement. Both of them are authorized to conduct I-9 audits. There's also within the Department of Homeland Security, so we've got the Department of Homeland Security, which is the umbrella agency, and within that you have Customs and Border Protection. Those are the friendly folks at the airports and at the border who admit folks into the United States. You have ICE, which is the enforcement arm of the Department of Homeland Security. And then you have USCIS, U.S. Citizenship and Immigration Services. USCIS's role is to adjudicate applications and petitions requesting immigration benefits. So for example, if your employer client wants to sponsor someone in an H-1B visa, those H-1Bs are filed with the USCIS. If you represent an employer whose employee wants to apply for naturalization, that naturalization application is filed with the USCIS. The USCIS has within it a division called the Fraud Detection and National Security Directorate. And what that means specifically is that with every H-1B petition that's filed and with every L1 petition, this says TNs, and that's also included there too. L1 is another one. The L1 is an intercompany transferee. H-1B are professionals, and TNs are based on an agreement that our country has with a trade agreement that we have with either Canada or Mexico. Whenever an employer files those petitions, they're filed with USCIS primarily. And the FDNS directorate, their role is to go to the employer's site to investigate the veracity of the information that's on those petitions. So they're just making sure that the individual really is a software engineer, is really getting paid $100,000, is really working at this location in Minneapolis, Minnesota. So they're really there to make sure that there's no fraud in the H-1B, L1, or TN petitions. With each of those site visits, the I-9 audits or the FDNS visits, the government usually provides some kind of notice. They usually say, we're going to look in your I-9 records. We're going to give you 3 days to produce these documents. With the FDNS, they don't always give notice, but when they do show up, and if you're not there, they'll try contacting you by the phone. I just had a phone call a couple of weeks ago from a client who had an FDNS site visit, and they were just checking, like I said, the veracity of the information on the forms. These are all other types of site visits, and all of these should be referred to human resources, but they're not the same as raids. They're not the same as raids where the Immigration Service appears without any authorization, without any notice whatsoever, and starts to conduct searches. So now that we know how we got to where we are, and now that we know what the difference is between the different site visits, now we look at the raids, and when we start talking about raids, we have to talk about the Fourth Amendment of the U.S. Constitution. And this is the amendment that protects from unreasonable searches and seizures by the government. So we're going to talk about that unreasonable searches and seizures very specifically. It sets up the requirement for issuing warrants by requiring that warrants be based on probable cause and that they provide sufficient detail of the place to be searched and things to be seized. We're going to talk about this in much more detail, but it's a good time to brush up on your constitutional law particularly Fourth Amendment. When we start doing Fourth Amendment analysis, it's really, really, really crucial to start by looking at what is a public area and what is a non-public or private area. And the reason why that matters so much is because there are enforcement activities that can take place in public areas and that cannot take place in private areas without consent or without a warrant. So we're going to talk about that in much more detail now. So the way to distinguish between a public area and a non-public area is by looking at whether or not there's an expectation of privacy. So obviously public areas are those areas where there's not an expectation of privacy. If I'm on the light rail and I hear someone talking on their phone, that conversation is that the person who's having that conversation cannot have a reasonable expectation of privacy because they're talking in a public space on that phone. So public areas are important to keep in mind because federal agents may enter them without a warrant and without consent. That's really important, particularly for clients that have public areas like hospitals that have waiting rooms, for example, or churches that might have a playground outside, or even a church that has a like sanctuary where people come on Sunday to worship. Federal agents may enter public areas and they do not need consent and they do not need a warrant. They can question people in public areas. Before the sensitive locations policy was rescinded, what we were starting to hear was that there are federal agents who would wait on sidewalks across the street from a sensitive location. And sidewalks are public areas. So if people come out of church, for example, and are seized by the federal government, the federal government can do that because they are in a public space. And so they can talk to the individual, they can ask for documentation, they can have access to that area because it's a public area. Public areas include, I'm thinking of now of what your clients may have within the physical buildings. They may have dining areas, they may have lobbies, they may have waiting areas, they may have parking lots. I had a retail client of mine say, can we tell agents that they can't park in the parking lot? No, you can't, because they can park in the parking lot because it's public. And outside grounds, except if those grounds are locked and not open to the public. Distinguish that from private areas. So private areas are those in which there is an expectation of privacy. In my office, for example, you can come in through the elevator and there's a lobby area and you'll talk to the receptionist, but then all the offices are behind closed doors. Those offices, there is an expectation of privacy because they're locked. You need a special key to get inside. And so non-public areas are those where access is restricted. And so these include spaces that may be unlocked during normal business hours that still require permission to enter. These include offices, restricted waiting areas, meeting rooms, auditorium spaces, respite areas. In order for a federal agent to enter a non-public or private area, that agent must have consent of the facility or must have a judicial warrant, which we're going to talk about very shortly. So as a recap, public areas, federal agents may enter without access. They can access documents, so without consent and without a warrant. They can access documents. Staff cannot prevent them from accessing public areas. Agents are permitted to listen to conversations in public areas, search items in public areas, seize any information they find in public areas, and even question individuals present in public areas. Again, as I mentioned earlier, this presentation is really geared toward the employer or the entity and their employees and the guest or patient, how they protect their guests and patients. But individuals should also be aware that they have the right to remain silent and do not have to answer. And so with non-public or private areas, agents have the right, they must have either the facility's consent to enter those areas or a judicial warrant in order to enter those spaces. So one way to prepare your clients for a site visit is to think about what areas are public and what areas are not public, and to mark those areas clearly with signage. So consent, let's talk a little bit about consent, because I feel like like it's very easy for someone to give consent, even if they don't intend to give consent. And once they do, it's really hard to close that door once you've given consent. So as I said, federal agents may search non-public areas if they have consent to do so. When an entity gives consent, they're basically waiving the warrant requirement. They're waiving the probable cause requirement associated with obtaining a judicial warrant. We'll talk about that in the next slide, in a couple of slides, not the next one, but soon. And so it's really important to keep in mind what are the requirements for consent. And there are two biggies. One is that consent must be voluntarily given. So an individual cannot be coerced into providing consent. It must be voluntarily given. And consent must be given by an individual with authority over the site to be searched. So what I often advise clients to think about doing is designating a person who has that authority. That would be the point person. So if the ICE agent does show up and asks the receptionist, can I get access back there? The receptionist can say, let me contact the point person who can help you. And that point person would be someone with authority. Again, you don't want to give them consent, but you also want to make sure that you're not accidentally giving them consent. So you, an individual, your client, a receptionist can consider saying, I cannot consent, I do not consent. You'll need to speak with a point person. So we talked about access in private areas and access requiring or agents able to access information in private spaces if they have consent or if they have a warrant. And so we talked about consent. Now we're going to talk about the warrant piece. It's a little bit more complicated, a little bit more detailed. And that's because there are two types of warrants. There is an administrative warrant, which is issued by the administrative agency. And then there's a judicial warrant, which is issued by a judge. And understanding the difference between the two is critical because one requires compliance on behalf of the employer and one does not. So let's talk about administrative warrants first. An administrative warrant is a document signed by an administrative agency, such as the Department of Homeland Security or the Immigration and Customs Enforcement, and not by a judge. You'll see in the image here at the very top, I have highlighted sample administrative Department of Homeland Security warrant. If you look just above that solid line, it says right on it, U.S. Department of Homeland Security. So it's not a judge, it's not a court. And the signature in the bottom, underneath those boxes, it's a signature by the agency, not by the judge. The purpose of an administrative warrant is to either make an arrest or to seize someone suspected of being subject to a final order of removal. So in other words, if somebody is suspected of being in the United States without authorization, if someone is in removal proceedings and a judge has ordered them removed, then the issuance of the warrant is to arrest that person and bring them to the proper authorities to finalize that removal. It's addressed to, if you look under this, at the top of this warrant on the image, it says to, in big bold letters, to any immigration officer authorized. So it's not really addressed to the employer. It's not really addressed to the store or the restaurant. It's addressed to an immigration officer. And that's because it's asking the officer to bring this person who's suspected of being subject to a final order of removal to federal immigration officers for execution. The reason why this matters is because administrative warrants do not grant access to non-public areas. Now, I'm just going to take a step back for a moment to say that this administration's priority is to remove as many people from the United States as possible who can be removed. The likelihood of them having warrants to do that is not very high because their goal is to round up as many people as possible. But they might show up with an administrative warrant. Administrative warrants are relatively easy to get within the administrative agency because it's the same agency that's doing the enforcement. So if you do find an officer that has an administrative warrant, your client, I should say, your clients will want to train staff to recognize the difference and to recognize that administrative warrants do not grant access to private areas. So with respect to actions to take, so you have an officer that shows up, he's got an administrative warrant, what do you do? Well, the first thing is, like we said earlier, staff must be very careful not to, I should say the very first thing is just remain calm. I think that raids, because they're unannounced, tend to surprise people and freak people out, for lack of a better way of putting it. And that's all understandable because this is not a pleasant situation. However, if the more that staff can remain calm, the better it's going to be for everyone. Staff must be careful not to say or do anything that could be construed as giving consent. Again, we mentioned earlier that once you give consent, it's hard to take it away. So you want to be really careful not to allow officers access when they don't have. So in other words, if an officer shows up with an administrative warrant and says, I want to go through your patient records. They show up at a hospital. They say, here's an administrative warrant. I want to see your patient records. If you show them patient records, that is evidence that is now admissible because of consent, not because they searched with the wrong warrant, because someone gave them consent to do that. And so that's why you want to make sure that people know not to give consent, even accidentally. That's why we want staff to refer the agent to a designated point person who's well versed in this area. You can ask the agent for identifying information. What's your name? What's your badge number? What's your department affiliation? ICE agents should carry these. We have had reports of ICE agents that carry these, and when asked for their badge numbers, the agent shows it and then puts it away and says, you don't need any more. You want to record that kind of behavior. I've had clients that have asked agents for their badges so they could make photocopies of them. I mean, that, and some agents have actually done that, but usually they won't. But it's just something to be aware of. Phones are really good at recording information, and people can record things on their phone if they want to. And we'll talk about that in just a few minutes. But again, staff should not allow ICE agents to enter non-public or private areas. I say clinic or hospital, but it's really any employer, as administrative warrants do not authorize a search or entry by an agent into a private area. Let's compare that to judicial warrants. A judicial warrant is an official court document, and it contains the designation of a specific federal or state court and is signed by a judge of that court. So if you look at the image, I highlighted United States District Court. It says right underneath that search and seizure warrant, you'll see, near the bottom there, the signature is a judge's signature, not an agent's signature. The reason why this is so important is because in order for the Department of Homeland Security to have a judicial warrant, they have to first go to a court, and they have to show that it has probable cause to search the location that's being searched. So in other words, it's a higher standard. They have to go through the steps. And as I said earlier, the goal isn't really to go through the steps. The goal is to just kind of round up as many people as possible. So this is an extra burden for the government. And it's a burden that's in place because of the Constitution. It's a burden that requires the agency to present evidence to a judge that says, this is why we need access to this information, this site, this data. And they have to be able to show that there's probable cause of some illegal activity that's happening. Only with judicial warrants is an employer obligated to comply. So if an agent shows up with a judicial warrant, again, staff can stay calm. Easier said than done, I fully recognize that. They can ask the agent for official identification information, such as name, badge number, department affiliation, like I said earlier with the administrative warrants. But the point person will want to look at the judicial warrant to ensure that it's, one, a judicial warrant and not an administrative warrant, and that it's signed by the judge or by the magistrate. If the agent does happen to have a valid judicial warrant, Employees must allow agents to enter the private area, but only if the warrant provides sufficient detail of the place to be searched, includes the time and scope of the search, and this is important, the search is within the place, time, and scope listed on the warrant. So, for example, if an agent shows up with a judicial warrant to search the offices of Nyland Johnson Lewis on Tuesday, April 22nd, and they show up today, we can tell that agent today's Monday, April 21st, and the warrant says Tuesday, April 22nd. This is not a valid search because you're outside the scope. So if you want to search the space, you either have to come back during the time that's listed on the search or on the warrant, or come back with a different warrant. If the warrant says that we want to go to Burger King located in Richfield, and they show up at Burger King located in Bloomington, then that Burger King in Bloomington can say this is not an appropriate search because it's outside the scope of the warrant. You're at the wrong location. So even if they have an administrative warrant, there are limits to that warrant. And so when I have corporate clients who ask me questions around this very thing with the scope of the search, I tell them, walk around with the agent. If the scope of the search is they have access to the human resources office at this particular company, make sure they don't go into any other offices in the human resources office. That's what you want to make sure that your point person follows the agent to make sure that they're within the scope of the search. Now, the reality of the situation is that it's possible that the agent may access or try to access or even force their way into locations that are outside the scope of the warrant. If that should happen, don't stop them from doing that. Instead, what would happen, the reason why that is important is because in the future, when there's a court challenge, and if the employer wants to challenge the constitutionality of that search, that's where the evidence comes in. That this search was outside the scope. We gave them access to building A. They went into building B. We told them they can't go in building B. They went in anyway. So all that evidence that's gathered is inadmissible evidence because it was unconstitutional. That's where it comes up. So even if you can't stop them from accessing places that they don't necessarily have access to, you can challenge it. There are two other documents I'm going to mention that don't come up very often, but I just want folks to be aware of them. One is an administrative subpoena, and that's a document, again, signed by the agency official, not a judge, used to make an arrest or confiscate records. And because it's an administrative subpoena, compliance is also not required. So this is more, this is not very likely to happen, but the idea of the subpoena is to try to gather documentation that can be used in the future in court. In the same way, there's something called a judicial subpoena, and that's a document that's signed by a judge used to compel appearance or production of records in court by a certain date. So in the unlikely event that the agent will have a judicial subpoena, compliance is not required, and a judicial subpoena may be challenged. I shouldn't say compliance not required. It's not immediately required. So in other words, a subpoena would typically say something like, you need to give us these records by such and such a date. So compliance is not immediately required if they show up with one, and a judicial subpoena may be challenged in court later as well. So as a recap of the documents that agents may have, and again, the likelihood of them having any of these is probably not very high, given the priority to just round up as many people as they possibly can. But it's still, the search is still constitutionally protected. An administrative warrant, it's signed by the ICE official, not a judge. It's used to make records, make an arrest or to confiscate records. Compliance is not required. A judicial warrant, however, is signed by a judge. and that's used to make an arrest or to confiscate records, and compliance is required if the facility on the warrant is identified. But remember, compliance is limited to the scope of that judicial warrant. When we get into the subpoenas, an administrative subpoena is a document signed by an ICE official, the Department of Homeland Security official, not by a judge. It's used to compel appearance of or the production of records in court by a certain date. Compliance is not required, as opposed to the judicial subpoena signed by a judge, which would compel the appearance or the production of records in court by a certain date. Compliance is not immediately required, but the facility may challenge it in court if they would like to. So now that we know the difference between what's a private space, what's a public space, and what the facility's obligations are with respect to each of those, and now that we know the difference between an administrative warrant and a judicial warrant and the employer's obligations to those, let's talk a little bit about how to prepare your clients for a raid. So first and foremost, it's always important to have a written response plan. And in that response plan, the employer or the entity will want to designate a point person or persons who can field these calls. The plan should inform employees of what their rights are. They do have the right to remain silent. They have the right to request an attorney. They can be asked questions by the agent, but they don't need to answer those questions by the agent. An employer can use signage to distinguish between private spaces and public spaces. That's something that can easily be done, which is probably not a bad idea anyway. The written response plan can include guidelines for documenting a raid, such as recording names or agents, recording the scope of the search, recording any items that might have been seized, maybe even ask the guidelines for asking agents where they're taking people if they do take people. Those are procedures to safeguard employees. Companies who want to train their employees, again, they're not obligated to answer, not give consent, but also make sure that they're pointing the agent to the designated point person. And above all, people should not, well, maybe this is the next slide, actually, I think, during the raid. This is preparing for it. Always a good idea to consult with legal counsel. They want to make sure that your clients consult with you if there is a raid going on. Best practices during a raid. So those are steps that employers can take beforehand in preparation of a raid. Here are some thoughts about what employers can do during the raid. Employees can cooperate, but should be careful not to give unintended consent. I repeat that a lot because you'd be amazed. Agents will know that if they don't have warrants, if they don't have a judicial warrant, they know that they don't have access without a judicial warrant. So the way they will try to gain access is with consent. So we've heard cases, for example, of agents that call employers ahead of time saying, we are just doing a check-in with you just to see how things are going. They try to create this cooperative relationship. We're here to work with you. And then they start asking questions like, can we sit in on your I-9 meetings? Can we go talk to your employees about what documents they presented? So it's really, I mentioned consent a lot because it can be very subtle how they get consent. I will say that we're talking about worksite raids where they don't typically give advance notice. But it's important to also to keep in mind, I distinguished them earlier from I-9 audits and FDNS site visits, but it's also important to keep in mind that a raid could eventually lead to an I-9 audit as well. So that's why you want to try to cooperate as much as possible, but you want to be careful not to give unintended consent. And again, as I mentioned earlier, the goal of the target for these raids are to try to round up as many people as possible. The focus is on the employee, not on the employer, although it's very likely that they could lead to audits of the employer, such as I-9s. During a raid, it would be really helpful to have in place procedures to examine the type of warrant that's presented, if there is one. and the scope of the judicial warrant. If the agents insist, make it clear that the company does not give consent, but do not obstruct the raid. Right? And you also want to make sure you're protecting employee rights. And try to document as many things as possible. Names of the agents, which agencies they're from, copy of the warrant. They may be police as opposed to ICE agents. Copy of the warrant. You can record with your phone. You can accompany agents as they move around the workplace. You can try to protect privileged documents. You should protect privileged documents. Request a copy of list of items seized. You can request, if they do take people away, you can request, can we know where they're going so we can notify their family members, for example. Staff should be directed to not give false statements. So whereas staff can choose to remain silent, they really shouldn't choose to give false statements. That's not going to help them at all. Staff should also not try to hide employees or help them leave the worksite out the back door. And they should not shred or hide any documents whatsoever. And so that is the end of the presentation. I'm going to just unshare my screen so that I can start taking questions from folks, because I'm sure we have quite a few. I see that we have 6 at least.
Yes, we do have questions, John. Would you like me to read them to you?
Sure, thank you.
Okay, so there's a question related to school, where school has a locked door to enter, requiring staff to buzz in visitors. Would that then make the hallways, classrooms, and so on private areas? Same question for hospitals who have a locked door before entry into some areas.
Yeah, that's a great question. I would say that if the door is locked, obviously there's an expectation of privacy there, right? So the facility itself is not a public facility. It would not hurt to have a sign that says access limited to those with authorization. So if they ring a bell and the door is locked and ICE agents come in, then the question is, who do they approach at that point? I assume it's a receptionist, but it could be whoever it is that's there. That person can make it clear that this is a private space, and do you have permission to be here? It all comes down to whether or not the individual has the consent or the authorization to be there. In that kind of a situation, I would say that that's a private area because there's an expectation of privacy by the very fact that it's locked. Just because you're admitting them doesn't mean you're making it public. It means that you're verifying that they have authorization to be there. Because, like, what if they were a patient, for example? You mentioned it was hospitals, right? So if there's a hospital that has a locked door, you buzz that person in. You want to make sure that that person is the patient that's supposed to be there. So the fact that you let them in doesn't automatically make it public. But the argument is that you still have authorization in order to access other areas other than this reception area.
Thank you. My next question is, can one live stream a search?
I don't think that there's anything to prevent them from doing that. I would say yes. I would say yes, you can photograph, and I would say you can live stream the search. I think of, like, especially if the search is in a public space, right? Like, I think of George Floyd, that was kind of live streamed, wasn't it? Or the video was made public. So yes, that's permissible.
Thank you. Next question. I'm curious what the current enforcement status is for those employers who are required to use E-Verify, such as Arizona employers, or those who use it voluntarily. Are they at an increased risk for on-site visits?
Wow, what a good question. So I mentioned earlier that the I-9 form is the employment verification form that all employers have to complete for their new hires after whatever the date was in 1986, January 1, August 1, July 1. It's been a while. Most employers, anyone hired after 1986, which is most employers, most employees, the employer has to prepare an I-9 form. there is a software, if you will, or a database called E-Verify. And E-Verify is a national verification program. So not all employers are obligated to enroll in E-Verify. They can choose to if they want to. And there's certainly benefits to choose to enrolling and disadvantages to enrolling. And some employers are obligated to. There are some states that require employers to enroll in E-Verify. Employers that have contracts with the federal government have to enroll in E-Verify. And what E-Verify does is it verifies instantaneously the employment authorization status of any individual that you put into the system. Once you enroll in E-Verify, you have to enroll all your employees through E-Verify. You can't do it for some and not do it for others. That's one of the drawbacks to it. When an employer chooses to enroll in E-Verify, there's a memorandum of understanding that they sign. And within that memorandum of understanding, they sign a statement that says that they will agree to comply with site visits by the federal government. And so it's an odd statement because employers have to comply anyway. I think it's just a way to have E-Verify employers be willing to make that statement. But the same rules apply. The same rules apply with respect to the warrant requirements and expectation of privacy and Fourth Amendment protections. So if the question is, are E-Verified employers more likely to be rated? I would say that the answer, well, let me say one more thing. Let me say one more thing before that. The other thing that came out of one of the executive orders that was signed by the president is a push to try to make more and more, maybe all employers obligated to enroll in E-Verify. So I think what we're going to see is an uptick in employers who are registered in E-Verify. I think we're likely to see that, which wouldn't necessarily be the end of the world, but because when E-Verify was first rolled out, there were lots of problems with it. It gave false information. It just wasn't consistent, but they worked out a lot of those kinks. So I think most employers who are enrolled in E-Verify actually like it. The question is, are employers who enrolled in E-Verify more likely to see raids? I would say that I don't think E-Verify alone is going to mean that there'll be more raids, but because more employers will be enrolled in E-Verify, it might seem that way. So I would say not necessarily, but we are going to see more raids, and because more employers are going to be obligated to enroll in E-Verify, it just might appear that it's because the raids are happening among E-Verified employers.
Thank you. Next question. Can you give examples of not giving consent but not obstructing? Using the school example, if the decision maker states that they do not give consent, but the agent demands, please open the door, should the staff member open the door, reiterating that they do not consent, or should they refuse to open the door?
Yeah, I would say that if an agent says, open the door, and the staff person says, this is a private area, we do not, do you have a warrant to access that? And if the agent says no, then, and if the staff person says, well, because this is a private area, we do not give you consent to search. And if they say, open the door, or else I'm going to bust it down, I'm going to arrest you, at that point, you want to go ahead and open the door, but you want it to be on the record that this was not authorized, that this was not, that, and that's where you get to challenge the constitutionality of it later. I wouldn't obstruct the site visit, but I also would make it very clear that we don't give you consent. Well, one example that I had, I gave this presentation to another client that was a hospital, and they had a really good question. They asked, what if the agent comes into the reception area, which is a public area. So they're there and they're talking to someone who's a patient in that public area. And then that patient gets called into their doctor appointment. So then the receptionist will say, the doctor will see you now. And then the person gets up, the question was, what if the ICE agent follows that person? And my advice in that kind of a situation would be for the staff person to ask the patient or the customer right in front of the officer, do you give this officer consent to accompany you to your doctor appointment? And if the patient says no, say to the officer, the patient does not get, this person is not giving you consent, and we are not giving you consent. If they still barge in anyway, I wouldn't stop them from doing that, but that's not the same thing as consent by not stopping them.
Okay, and then next question, if the client is presented with an administrative or judicial subpoena and chooses to comply, does that impair their ability to later object to a subsequently issued subpoena to issues related to subpoena, I think, or other administrative demand, whether unrelated or perhaps related, for example, ask for documentation, reacts for certain days, then subsequently ask for broader date range?
No, whenever there's a subpoena, so what the subpoena is doing, it's asking for records that will later be used as part of a judicial proceeding. And so what the question, what the person's asking is if the employer complies with that subpoena, can it be challenged in the future, whether for this one or for something related to this? And the answer to that is yes. You can still challenge the subpoena in the future. Just complying at that point doesn't mean that you can't challenge it in the future. My recommendation, though, is a lot of times the subpoenas will say we need these documents by a certain date. I would not do it right away. I would say, okay, I acknowledge that you need these by a certain date. Thank you for letting me know that. We will discuss that and get back to you. And that way you're not, because there's not an expectation that you would turn over documents right away if they do present a subpoena. It's really, you will turn over these documents by a certain date. And as long as you have that window, I wouldn't recommend providing that documentation at the time of the site visit.
Thank you. We have about 2 questions. We have about 1 minute left, so just time warning here. For a client that is a sensitive area, a school, is the guidance any different for preparing students for RAID versus for school staff?
I think there's a lot of difference because there's lots of, I got this request, similar request with my healthcare clients as well. And it's because there are in the healthcare setting, there are HIPAA laws that prevent the release of patient information. And in the school setting, there are FERPA laws, which prevent the release of student information. And those laws, from my understanding of those laws, is that they still guarantee the protection of that sensitive information. So those are separate from the immigration laws that we're talking about. So in those situations, I often instruct my clients to tell the agent, we cannot release this information because it's a violation of FERPA laws or HIPAA laws. And because of that, we cannot give you this information. When that, usually what I've heard, this just happened in Los Angeles, I think it was, just last week. In those kinds of situations where you push back a little to tell them that there's sense that there are other laws that prevent you from releasing that information, they tend not to push it. That's what I've been seeing in hearing in those types of raids where they ask for that information and you tell them this is not something that we can release because of other laws prevent us from doing it. You'll need a warrant in order to do that, a judicial warrant in order to do that. I don't think that they'll push further. They might ask it first, but I think if you notify them of the other laws that protect that information, they're likely to respect that. That might be
Thank you.
wishful thinking. That might be wishful thinking, but that's how it's been panning out so far.
Okay, and quickly, last question, do the rules for subpoena, so that goes back to the subpoena question, do the rules for subpoena also apply to summons?
I don't know the answer to that, honestly, because that's a criminal law question and it's not likely to come up in a immigration raid. Unfortunately, I don't know the answer to it.
Okay, I think that concludes our presentation. No more questions. Thank you very much, everyone. And there's thank you for this presentation. The context was great and easy to understand, very practical advice. Thank you so much, John. And
Thank you.
everybody, have a great day.
Thank you. Bye-bye.